Hello, everyone, and welcome to our program this afternoon, The Body Politic, Boston Jews, Disability, and U.S. Immigration Policy with Dr. Hannah Zaves-Greene. My name is Rachel King. I'm the Executive Director of the Wyner Family Jewish Heritage Center at American Ancestors, and I will be your moderator today. The Wyner Family Jewish Heritage Center is a research and education center dedicated to preserving New England Jewish history, to exploring Jewish heritage, and to illuminating the American Jewish experience for wide audiences. We are located in Boston at American Ancestors, America's founding genealogical organization and a national center for family history, heritage, and culture. Today, we are so pleased to spotlight the work of our historian in residence, Dr. Hannah Zaves-Greene, and to gain new insights about Jewish immigration and disability history from her. But before we get started, I just wanted to make a few housekeeping notes about this webinar. You in the audience will be muted throughout. If you have questions during the presentation, please type them into the Q&A panel at the bottom of your screen, and we will try to get to as many as we can following Hannah's presentation. Also, as we are broadcasting from different locations, we ask if you'll bear with us if we experience any technological issues. And no matter what, we will be sending you a link to the full recording of this session afterward for you to watch or share it later. So now it is my great pleasure to introduce our speaker today. A scholar of American Jewish history and disability, Dr. Hannah Zaves-Greene is the Jewish Heritage Center's 2024-25 Historian in Residence, a position generously funded by our supporter, Richard Schilder, in honor of Justin Wyner. Hannah's research is also supported by the National Endowment for the Humanities and the New York Public Library, and she is taught at Sarah Lawrence, Cooper Union, and the New School. She received her PhD from New York University, where she also focused on disability. Her PhD in Jewish Studies from New York University, where she also focused on disability, gender and sexuality, and legal history. And her forthcoming book, Able to be American, Disability in U.S. Immigration Law and the American Jewish Response, is under contract with the University of North Carolina Press. Currently a fellow at University of Pennsylvania's Katz Center, Hannah also consults for the National Museum of Immigration on Ellis Island and serves as Director of Partnerships and Outreach for the Disability History Association. So without further ado, welcome, Dr. Hannah Zaves-Greene.
All right, thank you so much. Let me get the slide set up. Can everyone see okay? Rachel, you got it? Awesome. And thank you for that introduction, Rachel, and thank you so much, everyone, for joining us today. I'm really excited to share this research with you. So let's get into it. The official policy of the United States is, and always has been, one of neglect toward the newcomers who are left to shift for themselves. Magnus Greenman wrote in Boston's Jewish Advocate on August 11th, 1936, in an article about several of the critical roles played by HIAS, also known as the Hebrew Immigrant Aid Society. HIAS served as a vital source for legal assistance with immigration, naturalization, and other related bureaucratic processes. Even the US government itself, Greenman wrote, would contact HIAS for advice about documentation requirements for international travel. HIAS also played a critical role on Boston's docks, a chaotic scene of unfamiliar languages, opportunistic predators, and intimidating government officials awaited immigrants as they disembarked. HIAS officials, to ease immigrants' transitions, waited on the docks to greet them, collect and verify their information, and guide them through the labyrinthine, often treacherous process of inspection, where any indication of physical, mental, or moral defect could result in deportation. Abraham Alpert, who some of you might recognize by his pen name, Ish Kovno, helped found the Boston chapter of HIAS in 1904 and led the chapter until his death in 1939. And on the screen in front of you, you can see 3 of Alpert's access badges from from right here in the JHC archives. The cards show 3 of the different agencies in charge of Boston's docks between 1914 and 1928: the Customs Department, the U.S. Marshals, and the City of Boston Police Department. Alpert, himself an immigrant, often personally accompanied his team to the docks when ships arrived. Hyas, working from a manifest of the ship's Jewish passengers, attempted to interview each Jewish immigrant as they disembarked from the ship, asking about the immigrant's age, marital status, and family composition, along with the address to which they would go if admitted to the country, and the name of a guarantor who could vouch for them. Often, Jewish immigrants required more complex assistance from Hyas. An immigrant might need help if their guarantor had moved to a different address or could not be reached, or if the immigration authorities had not released the immigrant's luggage before their train departed, or if the immigration inspectors declared one child to be defective after admitting the rest of the family, thereby requiring the deportation of the so-called defective child in the parlance of the day. In some cases, immigration officials would insist that a parent return to Europe with a child. In others, they would send the child back to Europe alone, and Boston's highest leaders would contact their European colleagues to meet the ship and find the child a place to live. To help immigrants resolve issues, Hyas maintained an intricate network of offices and affiliates around the country who could assist with communication and logistics in other cities. But the question remains, however, why the need for Hyas in the first place? So to explore that question, let's go back in time to the end of the 19th century, a period of rapid ethnic, racial, and religious change in the United States. On March 3rd, 1891, in the midst of growing anxiety about the increasing ethnic and religious diversity reshaping the dynamics of American life, Congress passed a sweeping new immigration law. Revising and expanding the 1882 Immigration Act, the 1891 Act began by enumerating the classes of immigrants excluded from admission into the United States in the very first paragraph. At the top of the list, all idiots, insane persons, paupers, or persons likely to become a public charge, classifications inextricably intertwined with national origin, race, religion, gender, and sexuality. Later in the same passage, Congress banned persons suffering from a loathsome or a dangerous contagious disease, among others. These methodically enumerated categories made American legislators' priorities abundantly clear. Echoing the Immigration Act of 1882 that first introduced the public charge law on the federal level, which ostensibly aimed to exclude immigrants who would depend on public money from entering the country, but in reality discriminated on the basis of presumed health status and ability, the 1891 iteration interwove poverty, illness, and real or perceived disabilities, conflating and subsuming them under the public charge provision. Not only did public charge betray the rising American fear sparked by skyrocketing rates of immigration, it placed ill, impoverished, and disabled immigrants in the same category as those convicted of a felony or other infamous crime or misdemeanor involving moral turpitude. Simply put, it equated disease and impairment with criminality and indecency, speaking volumes about Congress's vision of the ideal American. So, okay, within this context, let's take a look at a brief case study to get a sense of how the public charge law impacted Jews in America and how it fostered a targeted response from established American Jews in the country. Bluma Shapiro, a young Jewish immigrant girl from Russia, found herself caught in the crossfire of precisely this immigration law. In December 1911, American immigration officials nearly illegally deported 14-year-old Bluma, falsely claiming that she was a public charge. It all started when the New York State Commission on Lunacy endeavored to force Bluma's deportation as an allegedly insane or mentally defective immigrant, premised on what turned out to be not only a flawed, but a cherry-picked interpretation of the public charge rule. Bluma Shapiro's terrible predicament by no means represented an anomaly for immigrants deemed defective, imagine air quotes, either upon arrival or shortly thereafter, who had migrated to the United States in the late 19th and early 20th centuries. Doomed by their diagnosis of defect, these immigrants faced a harsh federal law and a still harsher administration thereof that considered them unworthy of American national belonging and citizenship. Establishing a precedent for increasingly austere eugenics-based legislation that would swiftly proliferate over the ensuing decades, American lawmakers and immigration officials wielded the public charge law to exclude and deport so-called undesirables, predominantly emphasizing defective immigrants or those supposedly ill or disabled. Now, okay, as for Bluma herself, 2 years after Bluma's family came to the United States from Russia, she began to experience pervasive physical pain that her doctor attributed to significant life changes, making a note that she had no history of either physical or mental illness. Shortly afterwards, Bluma accidentally dropped her baby sister. Badly frightened by this circumstance, she became irrational and melancholy and acquired the belief that she had killed the infant. Still, Bluma's doctors issued a positive prognosis, indicating that they expected to discharge her fully cured from the hospital. While we don't actually know what happened to the baby, the record suggests the baby was fine. But the wrench was, however, that since the hospital had disingenuously misrecorded Bluma's family's financial status at the time of her admission, claiming that they fit into a higher socioeconomic bracket than her parents reported, the New York State Commission on Lunacy asserted that the hospital had received insufficient compensation for Bluma's care. As promised, her family had paid the prearranged sum of $3.50 a week for a state institution, which her mother asserted was the most that the family could afford. Rejecting payment from Bluma's parents, the commission then claimed that the hospital had not received full payment for her care, thereby making Bluma a public charge and subject to deportation. The National Council of Jewish Women, or NCJW, here entered the scene. Founded at Chicago's watershed World's Parliament of Religions in 1893 by acculturated American Jewish women for American Jewish women, NCJW aimed to foster Jewish religious education and engagement, and soon thereafter, Jewishly inflected civic participation. NCJW quickly invested themselves with the responsibility of protecting immigrant women and girls, both during and following the immigration process. From the outset, NCJW operated on the margins, originating as it did as a result of Jewish women's exclusion from the male-dominated Jewish religious landscape, and organizational landscape for that matter. Turns out, Jewish women essentially wanted to do more than serve coffee and refreshments, as their male counterparts at the Parliament of Religions had requested them to do. Shortly afterwards, in 1903, founding member Sadie American established NCJW's new Department of Immigrant Aid, which maintained a station at Ellis Island from which councilwomen could reach and assist new immigrants. Accordingly, council volunteers thoroughly knew that even if, on a nigh impossible chance that Bluma was or had been at one time insane, the severity of her condition did not warrant deportation. Several months into her hospitalization, Dr. William Mabon of Manhattan State Hospital opined to NCJW that Bluma continues sad, depressed, resistive, and requires tube feeding. She is still inaccessible to examination, and when questioned, repeats over and over, "I want to go home." Still, he added that he believed she had a fair chance of recovery, evidenced by her desire to return to her family and her positive response to arts and crafts. Though her symptoms could lead to the diagnosis of insanity, they could also just as easily be ascribed to her experience as a teenage girl, institutionalized for months alone in a new country, threatened with deportation and permanent separation from her family, and all the while subjected to frightening and invasive treatment. Regardless, however, of whether doctors had initially diagnosed her correctly, the hospital superintendent documented her curability if permitted to continue on as a patient, an apparently common outcome at the hospital. The percentage of recoveries on those admitted, Dr. Mabon wrote in his report to the hospital's board of managers, has been reduced very materially by the fact that 209 patients during the year were sent back to their homes in other states or countries. Many of these patients, he explained, were suffering from recoverable forms of insanity, and undoubtedly, if they had remained under treatment sufficiently long, would have added materially to the percentage of those who recovered or improved. Leaders of Boston's Jewish community also recognized that the federal government could use financial status, as it did for Bluma, to justify deportation of immigrants already living in the United States. Years later, in 1938, leaders at the Combined Jewish Appeal reflected upon the preceding decades, aiming to produce a report about Boston's history of Jewish immigrant aid. According to one draft of the report, a critical shift in the narrative took place in 1894. Up to this point, according to the report, it was a general belief of Boston Jewry that poverty was an act of God, and that the poor have a permanent place in God's established order. Now, Boston's Jews were changing their concepts of poverty and of charity. They were reaching the point where they began to realize that poverty was not God-made, but man-made, and that something must be done to eradicate the causes of poverty. In 1895, 1 year after Boston's Jews changed their concepts of poverty and of charity, according to this report, 5 Boston Jewish groups joined together to establish a coalition, hypothesizing that fundraising would be easier as a collective group. That first iteration of the Federation of Jewish Charities included a burial association, a sewing circle, a home for orphans and the aged, and Boston's United Hebrew Benevolent Society, which focused on financial assistance for immigrants, Jewish and others, experiencing what they called temporary income disruptions. In one such instance, documented in one of only 6 Benevolent Association case reports in the GHC archive, 22-year-old immigrant Annie Aronson approached the United Hebrew Benevolent Association in December of 1893 to ask for help. Annie had arrived from Russia in the summer of 1892 to join her husband Albert, who had come to Boston a year earlier. According to Annie, her husband did not care for her of late and had recently abandoned Annie and their 5-month-old baby, leaving to parts unknown. The Benevolent Association voted to give Annie $1 per week to buy food, which Annie at first refused, but eventually accepted. The caseworker closed the file after 8 weeks of payments, with the final update on February 24th, 1894. The man lives with Mr. Rosenthal and is separated from his wife. Recommend to do nothing. In another United Hebrew Benevolent Society case, this one from the summer of 1893, Aaron Aronofsky of 13 Sheep Street, which just across from the Old North Church, dropped a brick on his foot, leaving him temporarily unable to support the 3 of his children who had accompanied him to Boston. Before he recovered, the Hebrew Benevolent Association voted to give him a total of $7 in cash, $8 of groceries, and 1/4 ton of coal. These 2 cases from the United Hebrew Benevolent Association point to a more widespread injustice that immigrants in the United States confronted as NCJW understood. Accordingly, in Bluma's case, NCJW established a coalition of leading American Jewish attorneys to advocate on her behalf. First and foremost, Sadie American turned to Max James Kohler, known among his colleagues as the champion of the immigrant par excellence. Born in 1871 in Detroit, Kohler had come of age as immigration rates escalated swiftly, especially of Jews arriving from Eastern Europe, due to technology that enabled speedier and cheaper passage across the ocean. Thanks to his father Kaufman Kohler and mother Joanna Einhorn Kohler, the young Max spent his childhood immersed in an illustrious cohort of American Jewish religious and social reformers and thought leaders. Now, Kaufman Kohler was a really big deal at this time among arguably the most important American Jews of his moment. So, like, think about, he's kind of the guy CNN would go to if they needed a Jewish opinion. and there was CNN at the time. The household where Max Kohler grew up was awash in religious ideas, innovations, heresies, and the most contemporary perspectives on how to do Judaism in America. Despite this, as his close colleague Abram Elkis described, Kohler rejected what he called the unwholesome barriers dividing the so-called German Jews who settled in the United States in the mid-19th century, like Kohler's family, from the Eastern European Jews who arrived at the turn of the 20th century, like Bluma, for whom he tirelessly fought. To apply these ideas and ideals, Kohler entered the legal profession, serving as an assistant U.S. attorney in New York City in 1894, before devoting much of his career to pro bono cases on Jewish and non-Jewish immigrants' behalf. Kohler would go on to argue immigration cases before the United States Supreme Court and lower federal courts, regularly citing his Jewishness and Judaism as the animating impulses driving his work. From his early days appearing in court, Kohler emphasized that the government must act justly, drawing a distinction between the law and its implementation, a theme that drove his commitment to the civil rights of the individual, even against government officials, when he believed that they were exceeding their legitimate powers. He scrupulously adhered to this perspective, whether representing immigrants or citizens, since where there was injustice to an alien, he saw justice withheld from a future citizen. Kohler also advocated on behalf of Hyas's Boston chapter when immigrants like Mottel Wyner, initially documented by Boston Hyas, found themselves transferred to Ellis Island pending deportation. Wyner had arrived in Boston in December of 1912. This Hyas intake slip from the GHC's Hyas collection shows that Wyner, age 32, worked as a tailor. However, immigration officials stopped him for two intertwined reasons: likely to become a public charge and poor physique. The case slip indicates that officials then sent Wyner to Ellis Island for deportation. Irving Lipsitch, Hyas's representative on Ellis Island, reported back to Boston the official basis for Wyner's exclusion and confirmed he would determine if an appeal of the government's decision would be possible. 6 days later, Lipsitch's office reported back to Boston that although Wyner's case had stalled because attorneys for his relatives had not filed an appeal, Max Kohler had stepped in to help facilitate the legal appeal. By February 19th, Wyner's former employer had directed Kohler to file the case, but the New York office expressed concern regarding the outcome. The letter adds the detailed cause of Wyner's rejection, noted on his medical certificate: frail frame, poor muscular development, weak abdominal walls, parenthetically, poor physique. Ultimately, officials denied the appeal, and U.S. Representative James M. Curley, future mayor of Boston and governor of Massachusetts, informed Hyas of the result, adding that the case was hopeless from the outset due to the physical condition of the alien. Over the years, however, Kohler won numerous difficult or hopeless cases, garnering a long-standing reputation as a pro bono immigration attorney. By the spring of 1911, when delegates of the Baron de Hirsch Fund conducted a routine visit to the Hebrew Immigrant Aid Society Ellis Island office, attorney Irving Lipsitch recounted that Immigration Commissioner William Williams had refused to cooperate with his request for Jewish immigration records. Williams, Lipsitch explained, was afraid of Mr. Kohler, who sat on the fund's executive board, and does not want to give him an opportunity months later to confront him with decisions when he acts contrary to those previously made. So, okay, to recap, what we've got is essentially this government official, Williams, terrified of this American Jewish lawyer, Kohler, because Kohler kept relentlessly holding him accountable and refused to let up in the name of justice. To be fair, Williams had good reason to fear Kohler. In his capacity as a highly esteemed American Jewish attorney, Kohler dedicated himself to justice for immigrants of diverse backgrounds. Reflecting his upbringing, which emphasized a commitment to social justice as both a religious and civic act, Kohler dedicated himself to defending immigrants' rights and fighting for a just federal government. Among the numerous legal and social causes to which Kohler devoted himself, federal immigration law's public charge provision, which pathologized poverty and commodified health, ranked high among his priorities. But what particularly troubled Kohler was what he termed public charge's elasticity, as it granted individual immigration officials tremendous discretion in enforcing the law. By the time the Connecticut-born William Williams ascended to his position in 1909, both the Jewish press and communal organizations had long recognized that the extensive discretion codified in the law posed a distinct threat to immigrants. Still, conditions at Ellis Island changed dramatically when Williams succeeded the previous commissioner. Under Williams, Jewish immigration advocates felt heightened pressure to combat the law, both to loosen its grasp on Jewish immigrants and to deflect associations of illness, poverty, disease, and insanity away from American Jews themselves. During and following Williams' tenure, officials increasingly tended to reject Jewish immigrants, often unfairly, if they displayed even a remote likelihood of becoming public charges. These officials frequently levied the claim of poor physique and later insanity as license to debar specifically Jewish immigrants, whether or not the charge had any basis in reality. Certainly, officials' rejection of immigrant populations did not apply to Jews alone. Each so-called inferior group allegedly exhibited its own particular predisposition to a set of undesirable traits. Public Health Service physician Alfred C. Reed detailed the specific defects to which each race tended. Greeks, for example, he said, ostensibly shared Jews' problem of poor physical development, frequently referred to as poor physique, as he described it. Jews, in addition, purportedly also demonstrated a predisposition to functional insanities, against which Ellis Island Assistant Surgeon Howard Knox cautioned inspectors, since, he explained, and my students love this quote, insanity and genius go hand in hand. Problematically, Knox elaborated, even though intellectually they may be very bright and have the ability to solve mathematical problems and pass all the complicated tests that can be given them, they still did not meet the basic criteria for entry because their defects arose rather in the emotional sense, frequently resulting in what he described as impulsivity and hedonism. Eastern European Jews' alleged mental defects then, according to this paradigm, merged with their so-called moral defects to make them fundamentally undesirable Americans, according to these prominent Ellis Island officials. In the midst of this increasingly xenophobic climate, the Federal Dillingham Commission that began in 1907, and still more so its resultant multi-volume 1911 report, particularly concerned American Jewish leaders. A bipartisan group of congressional representatives, the Dillingham Commission contended with the emerging concept of the immigration problem that it helped popularize to determine the effects of mass migration on the United States. One prominent source of their data turned out to be key states on the eastern seaboard, which had long been experimenting with restrictionism. To reduce Irish pauperism, writes historian Hidetaka Hirota in his landmark book tracing the origins of American immigration restrictionism, New York and Massachusetts built upon colonial poor laws for regulating the local movement of the poor to check the landing into the state of destitute foreigners. Massachusetts developed laws for deporting foreign paupers already in the state back to Ireland or to Britain, Canada, or other American states. Moreover, a group of intellectuals affiliated with Harvard lobbied for the extension and expansion of these sorts of policies to be enshrined as federal law. These intellectuals formed the Immigration Restriction League. This is the constitution of the Immigration Restriction League, or IRL, as established in 1894. In genteel language, they declare their opposition to what they term elements undesirable for citizenship or injurious to our national character. Between 1894 and their dissolution in 1921, the group advocated for restrictions on Southern and Eastern Europeans, among others, whom they considered inferior to Western and Northern Europeans. The IRL influenced the passage of legislation, especially the Immigration Act of 1917, and documents like the Dillingham Commission report. They also championed individual policies like numerical limits on immigration, increasing the duty that immigrants must pay and requiring literacy tests. In this informational booklet from 1903, the IRL presented its particular interpretation of what it perceived as the disparate literacy rates between the so-called desirable immigrants of Northern and Western Europe, of whom they reported that 96.1% can read, and the so-called undesirable immigrants of Southern and Eastern Europe, of whom they claimed 60.3% could read. However, upon closer inspection, the calculations failed to hold up to scrutiny, disingenuously weighting the numerical averages and erroneously grouping Spain, Portugal, and Southern Italy in the Eastern Europe category. Now, I want to briefly draw your attention to the bottom picture on the screen. Make a special note, if you will, of Syrians' presence in this list of other races alongside Hebrews. That's going to become really important later. So at this point, we return to the Dillingham Report. Prior to the report, by the late 19th century, Jews in the United States had become generally accepted as part of the imagined white family of races, according to historian Eric Goldstein. But as the years progressed, and particularly as Eastern European Jewish immigrants flooded onto American shores, identifying explicitly as a distinct race posed a mounting threat to Jews' sense of security in their chosen home. Given the real anxiety that this reality engendered, not least because Jews had historically and repeatedly been no strangers to the contingency of citizenship and national belonging, American Jews worried that the developing governmental tendency to classify them as part of the Hebrew race would lead to the eradication of their rights as white American citizens, much as Syrians had already experienced at the hands of the Department of Commerce and Labor in their reclassification as Mongolian in 1909. As such, the beginning of William's second term in 1909 ushered in a heightened urgency for Kohler. Ellis Island had already functioned as a perilous morass for immigrants hoping to obtain entry, but Williams took advantage of what Kohler called Congress's recklessly ill-considered tightening of the statutory language to weaponize public charge aggressively against newcomers. Not only did Williams utilize the poor physique label to exclude Jewish immigrants at Ellis Island, he also lectured to widespread academic and communal audiences on the topic and published articles in newspapers to promote the idea. Immigrants with poor physique, typically small and slight, lacking in vitality, and generally perceived as unfit, tended to come from Southern and Eastern Europe, Williams proclaimed. Kohler argued that immigration officials disproportionately ascribed poor physique, based solely on a cursory visual examination, often with no need for a medical certification, to Jews, at least until Jewish immigrants' alleged tendencies towards insanity, neurosis, and constitutional psychopathic inferiority superseded poor physique as a primary reason for exclusion. However, as Kohler reiterated over the years, not only did Russian Jews merely display what he asserted was their entirely normal constitutional tendency towards slightness in body that in no way endangered their ability to support themselves, this attribution of poor physique to Jewish immigrants also failed to take into account both the hazardous steerage conditions and the malnutrition that Eastern European Jews endured on their voyage to the United States because of the lack of food that conformed to Jewish dietary laws, or kashrut. Purported mental and physical defects, inherently indefinite and elastic terms in Kohler's words, provoked an increase in exclusions worsened by the trend of physicians basing their medical certifications on, as he described it, vague and sweeping generalizations unjustified in fact, like lack of physical development and lack of muscular development. Accordingly, Kohler kept a close eye on Williams, preserving copies of Williams' immigration rules and circulars in his own papers for his legal work, in his tireless pursuit of justice for immigrants. The principal classes excluded from admission into the United States, Williams declared in one such circular, mirroring the text of the updated law, are the following: idiots, imbeciles, feeble-minded persons, and epileptics, insane persons, and those who have been insane within 5 years, persons who at any time have had 2 or more attacks of insanity, paupers and persons likely to become a public charge, persons afflicted with tuberculosis or with a loathsome or dangerous contagious disease, including trachoma, persons suffering from any mental or physical defect which may affect their ability to earn a living. Illness, disability, and poverty, practically impossible to unravel as the law defined them, and inextricable from race, religion, ethnicity, and national origin as administrators enforced it, pathologized and criminalized immigrants who did not fit a narrow set of constraints deemed desirable. But even should immigrants successfully navigate immigration inspections and stay put within the United States without having recourse to public money at any time, much like Bluma Shapiro, the public charge law continued to imperil their ability to become naturalized citizens. Williams elaborated in his circular that an alien may be deported at any time within 3 years of his arrival, and that period of time only increases as we move towards the Immigration Act of 1917. The onus, as such, fell on immigrants to prove their right to receive treatment in the American public hospital without facing deportation upon discharge. The gendered variability in the law's enforcement represented the status quo that NCJW and Kohler had long recognized. NCJW's established emphasis at the crossroads of gender and disability inspired its initiative to care for the insane girls deportable under our immigration laws if they become a public charge, and concurrently to establish programs to support those dealing with such conditions as epilepsy, abuse, injuries, depression, and blindness to prevent them from becoming classified as public charges once they had arrived in the United States. Council volunteers kept watch over immigrant women and girls institutionalized in public hospitals with physical or mental defects, since such hospitalization and institutionalization readily led to deportation. When their preventive measures failed and immigrants received deportation warrants, council members obtained legal aid for them if their own appeals proved to no avail, much as happened in Bluma's situation. For NCJW, then, Bluma's experience represented the many cases which the organization had dealt with over the years. Jewish young women, in particular, frequently faced the threat of deportation because of dubious diagnoses of insanity. Over the previous 5 years alone, NCJW had handled approximately 500 insanity cases, all women. 240 of these women ultimately faced deportation as public charges. Much as Bluma experienced, the cause of these women's and girls' purported conditions frequently lay in what NCJW called nostalgia, or the frightful nervous strain that they have been undergoing for years due to poverty, persecution, or pogroms. Based on his own research, Kohler readily agreed with their analysis, viewing these diagnoses of insanity by physicians as examples of what he had earlier termed the dangerous elasticity of the public charge provision. Kohler also worked with the Hebrew Immigrant Aid Society, HIAS. This telegram from New York to Boston conveys a special request regarding the anxious New York relatives of passengers on the SS Newfoundland. The JHC archives contain numerous telegrams between New York, Boston, and several other cities as they coordinated the passage of countless immigrants, as well as this application that HIAS helped Lena Friedman complete for a replacement copy of her alien registration card. The reason? A small grandchild destroyed the card. So there you go. Similarly, in New York, HIAS kept a detailed record of case slips throughout the first 2 years of William's second term, documenting exclusions of Jewish immigrants because of alleged conditions, including heart disease, hardening of the arteries, hernias, senility, irregular breathing, quickened heart rate, poor vision, blindness, muscular atrophy, nervous system diseases, inflammatory conditions, dislocated hip joints, limps, psoriasis, lupus, and varicose veins, not to mention the ubiquitous poor physique. Although Williams acknowledged that these, as well as numerous other conditions that resulted in immigrants' exclusion, were not necessarily of a loathsome or dangerous contagious character, he still argued that they might render immigrants unable to maintain themselves economically and violated public charge's intention to keep out of the country a most undesirable class of people, as he said. To establish public charge status, and thus immigrants' admissibility, inspectors need to consider immigrants' physical ability and mental capacity, according to these inspectors' subjective interpretations, but definitively guided by the circular that Williams sent out, ostensibly in regards to the immigrants' reported occupation. Kohler denounced Williams' demand that immigrants demonstrate their entitlement to land, even though no law required that immigrants supply nigh exhaustive proof of their medical history to justify their entry into the country. Meanwhile, as Kohler noted, Williams insisted that immigrants certified by the surgeons for any mental defect, those who have ever been objects of public charity, those who appear to be devoid of ordinary intelligence, unmarried pregnant women, and children under 16 unaccompanied by either parent, and neither being in this country, all fell into the same undesirable pool. Bluma, still within her statute of limitations, readily fell into this category. Responding to Williams' abuse of power at Ellis Island, Kohler collaborated with a cohort of prominent American Jewish attorneys to recommend reforms that, at the very least, would enact safeguards to protect what they maintained were immigrants' rights to counsel and due process. Additionally, Kohler vehemently insisted that the conflation of medical and judicial realms had to cease. If doctors played judges and judges played doctors, he wrote, immigrants could not hope to receive a fair or accurate review and hearing. These reforms, among others, would at once recognize the United States' right to legislate immigration regulation while ensuring that immigrants received fair treatment and due process as befit the ideals of liberty and equality for which the United States ostensibly stood. Bluma, thanks in large part to Kohler's tireless advocacy, was permitted to return to her family and remain in the country. Still, she represented only one of the myriad cases of Jewish immigrants wrongfully threatened with deportation whom Kohler represented. For Kohler, then, the fight for justice was twofold. It at once included his expansive view of the parameters and meaning of American citizenship and Jewish religiosity, which combined to establish his vision for an upstanding and inclusive American civics. He fought not only as a Jew, but as an American, whose conception of justice remains solidly rooted in his Jewishness, serving as a reminder in his person that the two need not conflict and, in truth, sustained and strengthened each other. And in the process, he asserted something radical, that determining the boundaries of American citizenship and national belonging could not rest exclusively upon the elite few tasked with carrying out the law according to their own metrics and motives. On the contrary, defining and designing American citizenship and belonging required the participation of every American of all religions, races, and backgrounds, all those who called our beloved soil home. Thank you very much.
Oh my gosh, Hannah, that was fascinating, illuminating, and so shockingly timely, sadly. And I'd like to get into that in a minute. We do have some questions from the audience. Those of you in the audience, please do submit your questions in the Q&A. Hannah, I wonder if you could just bring the story forward for us. Kohler sounds like a hero for any period. And can you tell us what happened to him and also what happened to the public charge laws and did this get better as the 20th century wore on?
Yeah, in terms of the public charge legislation, still exists today and is still used to, it's still weaponized by the federal government against immigrants. So that discrimination on the basis of these traits is still enshrined in federal law. Different terminology to an extent, but the law still exists. In terms of Kohler, he sadly died an early death in 1934. He was appointed by Frances Perkins to be on her Ellis Island Committee, which was tasked with recommending reforms to basically humanize immigration policy and its enforcement in the United States. And according to his obituaries, and take it with a grain of salt because it's an obituary, but multiple individuals who knew him closely said that he essentially died of overwork. I believe he suffered from a heart attack, if I'm not mistaken, right after his work on the Ellis Island Committee report. But I mean, he's a really critical person in terms of establishing the kind of the patterns for how American Jews, especially American Jewish advocates and attorneys, would engage with the federal government. Also, I happen to really like him a lot. So there's that too.
Yes, it's always important and humanizing when you bring a figure like that into the story. And you also gave us case studies of people whom these laws and this discrimination was directly impacting. So speaking of which, I want to thank you on behalf of the Wyner Family Jewish Heritage Center of really digging into our collections and finding stories that illustrate this in these collections, and particularly in the HIAS, the Hebrew Immigrant Aid Society, the Boston Port, the records that we have here, the really extensive collection that we have here. So one audience member does ask, did you come across any immigrant cases in HIAS or elsewhere in your research that surprised you?
That's a really interesting question. When I first started this research, which originally began in the context of my dissertation and is now moving forward into a book, I would not say that I was surprised by anything I found, because my reading and research up to that point had revealed America's longstanding history of what we would now call ableism. And we still see that in federal law, more recently. Um, so no, sadly, there were no cases that surprised me, because it was over and over and over again the same pattern of, oh, Shmuley has varicose veins, so therefore he shouldn't be allowed in, or oh, I don't know, Leah has a limp, and so she shouldn't be allowed in, and so on and so forth. It's basically a cascade of awful. And these cases bear out again and again to demonstrate that the tremendous discretion codified in public charge that basically allowed individual immigration inspectors to pretty much use their judgment with limited supervision or oversight. It also kind of produced this this trend of seeing immigrants as fundamentally unworthy to become American unless they could definitively prove otherwise.
That is, again, all too timely as we apparently look to, any reason to keep people out or kick them out once they're here. There is another question here that is interesting. Near the beginning of your talk, you spoke in detail of a young girl kept in a state mental facility, as well as data about that facility's admissions and physicians. Are such records public in New York and Boston? In Michigan, such records are sealed and would require a court order by person of direct relative for health needs. How did you obtain such records? That's an interesting sort of research question,
Yeah,
a record-based question.
absolutely. a lot of that was in the collections of other archives. So, for example, NCJW, the National Council of Jewish Women, had transcripts of a lot of different legal investigations and affidavits and such. Kohler also kept a tremendous amount of papers. There's so much good stuff available, honestly. I mean, certainly at the JHC, also at the Center for Jewish History in New York, and on the internet. I mean, there's a lot that's currently available, either in archives or online. But it is a really interesting question because it also points to the fact that, unfortunately, in the context of disability studies, you rarely get to hear the voices of actual ill or disabled people. You're mostly hearing from the organizations, attorneys, officials, etc., who either worked with them or helped them or oppressed them or whatever the case may be. So I think that also brings up a really critical question of why are these organizations saving these specific records? What is it that they have to say, and what is it that perhaps they can't say, and how can we read that silence based upon what they deemed worthwhile to prioritize?
Interesting, interesting. Was there any sort of privacy protection at the time? I'm guessing with such discriminatory treatment of immigrants that the officials were not concerned with their privacy, but perhaps these institutions, as this audience member asks, you know, some of the mental facilities or hospitals or whatever might have been more careful. Let's see.
In terms of the confidentiality question, a lot of these documents come from third parties. So confidentiality didn't really apply in these contexts. And I mean, medical confidentiality as any kind of reliable, legally guaranteed right or protection, that really takes place more so also as a result in part of Jewish advocacy towards the latter half of the 20th century. But yeah, it's a fundamentally different way of understanding what a mind should look like, what a body should look like, and what any person had to do in order to justify their not only their admission to the United States, but their ability to remain in the United States. Because by the time you get to the 1917 Immigration Act, which I referenced, an immigrant could be deported as a public charge at any point within 5 years from their most recent arrival. So if they're on a train and it crosses the border, based on the sources I've read, the clock would start over again. So if you didn't naturalize quickly, which, as I'm sure we recognize, is not an easy thing to do, immigrants were constantly in peril. And so, you know, established American Jews are simultaneously concerned, oh no, how is this going to reflect upon us and what we view as our hard-won security and status in the United States? And also, what are we going to do about our co-religionists who are basically being weighed and measured and commodified and pathologized and all of that? So it's a really challenging moment in our history, but it's also demonstrably in character for American history.
We have a question from Nancy saying, do you know anything about the United Services for New Americans? I have a letter from 1951 that reports on a relative sent back to Russia from Boston in 1913 as she was, quote, feeble-minded. The family got regular reports from this organization after she was sent back. Eventually, she ended up in France, where she lived until her death in the mid-1950s. Have you heard of that service or organization?
Yeah, I've heard of the organization. I need to look further into it because it's not one of the primary ones I've dealt with, but I am familiar with the way that Jews used networks, particularly before World War II, but also especially post-war or during the war, to facilitate ways of um, aiding Jews, whether it was by helping them come to the United States or migrate elsewhere, or whether it was providing them support so they could stay in Eastern Europe, which we know how that ended. But yeah, it's there's a whole constellation of these organizations that worked very carefully together in very intricate webs. And also that letter sounds amazing, and I would love to see it.
Sounds like there was a series of letters over time. Michael asks, were Jews treated differently from other immigrant groups?
It depends on what you mean. The law applied the same to Jews as it did to other immigrant groups. I mean, for starters, Jews definitely had it much better than Asians, who were fundamentally barred from the country. Particularly, the most famous case is probably um, the systematic exclusion of Chinese people in the 1882 Chinese Exclusion Act. So Jews are never pointed out by name in federal legislation in terms of, saying that these people are deviant or defective as Jews. Rather, there's a lot of coded language, like the poor physique or the insanity. So Jews were treated differently in that they had their own specific diagnoses applied to them that tended to occur more frequently among Jews versus other diagnoses that would apply to the Irish or to Germans or to, whatever other nationality. Um, but I mean, everyone pretty much faced the same gauntlet. I mean, one of the examples that I've used frequently that my students both love and are completely grossed out by is that during the process of immigration inspection, in order to check for trachoma, which is an ocular disease, immigrants would line up, and an immigration inspector would use a button hook often and use the same button hook without cleaning it in between to lift the eyelids of
Ugh.
each immigrant in order to determine whether they had trachoma, which of course wound up spreading trachoma. Great article. 6 seconds per eyelid is a really interesting source if you're curious about more of the nitty gritty in terms of how immigration officials actually carried out the legislation.
We'll take just time for one more question. Well, there's one comment. I had a distant relative who had TB and was placed in treatment and allowed in after treatment. We also have a question. How did ableism and immigration laws at the time, if at all, affect Holocaust survivors with disabilities or trauma who wanted to immigrate to the US?
That's a great question. Most of my research focuses on the late 19th and first few decades of the 20th century. So I don't have too many details here, but I mean, as we know now, the public charge provision continued to exist. In fact, in 1930, President Hoover issued an executive order because, he was unhappy with the rates of immigration, but there had just been a flurry of increasingly restrictive immigration laws. So he didn't feel, based on what I've read, like he could, demand more legislation. So instead, he released an executive order instructing overseas consuls to as stringently as possible, enforce the public charge provision as a way to keep immigrants out of the United States. And I mean, this is 1930. So we know what happened in the 30s and 40s in Europe. And so you have these Jews, for example, let's take a look at German Jews, for example. You have these Jews who have been robbed of their property, of their financial resources, of, fundamental things that then render them ineligible to get to the United States. Additionally, it's worth noting that from 1933 to 1939, as Badamid Zucker points out, the quota legislation, which, the National Origins Act and the quota laws that basically said only so many immigrants based on this mathematical formula can come into the country at any given time and so on. From 33 to 39, the German quota didn't fill. German Jews were kept out of the United States during the 30s because of the public charge provision, among other factors. So, not a direct answer to your question, but it definitely had a very serious impact on prospective and desiring immigrants.
I'm so sorry to leave things there. Hannah, is there anything that you can leave us with for a positive, hopeful anything before we close out?
Yeah, I mean, this isn't a happy story. There's no triumphal ending. At the same time, in addition to that, I think it's really important to recognize these deep roots in American and American Jewish history, because that will give us a more complete, more accurate, more nuanced picture of the United States, of its legislation, of its evolution, and how it continues to evolve now. I think back to I think back to events over the past decade, and many people with whom I at least have interacted have been shocked at the kinds of things that are going on. My point back to them is, okay, let's look at the history of American immigration law and understand how we got here, because by understanding how we got here, then it becomes possible, A, to build empathy, but also B, to really have that context to allow us to form our own conclusions about the reality of what America has been, what it is, and what we want it to become. So not super happy, but it's something.
Well, I thank you so much. Thank you for the your insights, your really important work in helping create this fuller story and build greater understanding about our country's history and how we got here today, and maybe how we can ourselves work to shape a more inclusive, more hopeful path for immigrants and for us all. Hannah Zaves-Greene, thank you so much. This has been a terrific presentation. Thank you for being with us today. I also want to thank our audience for joining us. And once again, express gratitude to Richard Schilder, who has funded Hannah's position, and thank him for his generous support of the Wyner Family Jewish Heritage Center. I invite all of you in the audience to learn more about the Jewish Heritage Center on our website, jewishheritagecenter.org. While you're there, perhaps you might consider making a donation in support of our preservation and educational work. Thank you. As you leave this program, you'll be asked to take a very brief survey. We hope you'll take a minute to fill this out, as your feedback is really valuable to helping us develop further programming. We look forward to seeing you again soon. Goodbye until next time.
Thank you so much.